of the Honorable Court that the said constructive disengagement and termination of the claimant's employment by the defendant was contrary to the claimant's terms of employment and global best practices. A declaration of the Honorable Court that the purported termination of the claimant's employment by the defendant by its letter dated 24 June 2022 is wrongful. An order of 1,900,000 being unpaid salary arrears of the claimant from September 2022 to January 2023. An order of 50 million naira only as general damages for trauma and the hardship caused by the wrongful disengagement and termination of the claimant's employment by the defendant. An order of 5 million naira being the
Sorry, my lord, I think your microphone is muted.
Can you hear me now?
Yes, my lord.
Okay, I'll start from the beginning. This is the judgment of the case between Mr. Abayomi Femi Olugbenga and AfriGlobal Medicare Limited. The claimant instituted this action against the defendant via the form of complaint, seeking for the following reliefs: a declaration of the Honorable Court that the abrupt disengagement of the claimant by the defendant is wrongful and against extant labor laws. A declaration of the Honorable Court that the said constructive disengagement and termination of the claimant's employment by the defendant was contrary to the claimant's terms of employment and global best practices. A declaration of the Honorable Court that the purported termination of the claimant's employment by the defendant via its letter dated 24 June 2022 is wrongful. An order of 1 million naira being unpaid salary arrears of the claimant from September 2022 to January 2023. An order of 5 million naira only as general damages for trauma and the hardship caused by the wrongful disengagement and termination of the claimant's employment by the defendant. And an order of 5 million naira being the claimant's solicitor's fee for prosecuting this case, and an order for 5 million naira being the claimant's expenses for prosecuting this case. Trial commenced on the 4th of July 2024. The claimant adopted his witness statement on oath dated 1st of February 2023 and tendered 6 numbered documents as exhibits. They were admitted in evidence and marked as Exhibit C1 to C9. Unsigned letter of offer of employment dated 10th of September 2021 was marked as Exhibit C1. Letter of disengagement was marked as Exhibit C2. A letter dated 2nd December 2022 was marked as Exhibit C3. A letter dated 30th of September 2023 was marked as Exhibit C4. Another letter dated 26th of September 2022 was marked as Exhibit C5. And the signed letter of offer of employment was dated 10th September 2021 was marked as Exhibit C6. The claimant's case. The claimant's case is that he was employed as an internal control manager, in bracket manager grade. His offer of appointment was dated 10th of September 2021. He was to be on probation for 6 months before confirmation. He performed his duties with dedication and commitment to the corporate goals of the defendant. He was never issued a query for underperformance or misconduct. During trial, CW1 testified that he was given 2 months notice, but under Exhibit C1 and Exhibit C6, he was entitled to 1 month notice. But under probation, he would have been entitled to 2 weeks notice. That during the 2 months notice, he did not work, but he was paid his full salary. He also testified during trial that with regards to his performance, he did not have any conversation with his direct supervisor or any HR officer before he was issued the letter of termination, and he was never invited to see his line manager. The defendant's case is that the defendant confirmed that the claimant was employed as an internal control manager and his confirmation was subject to a 6-month probationary period. That the claimant supervisor, Mr. Abiodun Olubiyi, had on numerous occasions complained to DW1 about his poor performances, and he had several conversations with the claimant with regards to the poor performance and ways to improve, but there was no appreciable improvement. On the 19th of June 2022, DW1 received an email requesting a replacement. DW1 also testified that she had a conversation with the claimant prior to handing him the termination letter. He was informed that his performance during the probation period was unsatisfactory. The termination letter stated that the termination was to take effect on the 26th day of August 2022. He had a period of 2 months but was granted the garden leave for the 2 months period. By the letter of employment, he was entitled to 2 weeks late notice of termination during probation and 1 month notice for confirmed staff. The claimant therefore had 2 months notice together with the benefit of not working for the 2 months. With regards to the letter from the claimant's solicitor, the defendant said that he did not refuse to respond to the letter of 2nd September 2022. Rather, the defendant needed to investigate and get clarifications from the appropriate officers regarding the content of the letter. But before the defendant could respond appropriately, it was in receipt of letter of 26 September 2022. The decision to terminate was reached after giving the claimant a fair hearing. The claimant and another officer who was penciled down for termination were invited to meet with their supervisor/line manager, one Mr. Srinivas, with a view to giving them an opportunity to take their side of the story and defend their performance. The intention of the defendant was that where the outcome was positive, the termination letter would not be issued. The second employee's meeting yielded positive results, and he was not terminated. The claimant's meeting yielded no results, so he was issued with the termination letter. The defendant fielded one Ms. Irene Ola David as its sole witness. DW1 adopted a witness statement on oath dated 25th June 2024 and tendered 3 numbered documents which were admitted and marked as Exhibit D1 to D3. The letter of termination dated 24 June 2022 was marked as Exhibit D1. The email of 19 June 2022 from Mr. Olubiyi to the defendant's HR department was marked as Exhibit D2. Email correspondence of the defendant's HR department between 22nd of June 2022 and 4th April 2023 was marked as Exhibit D3. During trial, the testimony of DW1 was that the claimant worked for 9 months in the defendant's company and was issued a verbal query and feedback that she is not aware if there was a query issued to the claimant, therefore none was tendered in court. In addition, DW1 said she is not aware if DW1 had ever been disciplined. Finally, she testified that the claimant was tried by a one-man panel. In the body of the judgment, I have the defendant's final written address and the defendant's final written address. The claimant counsel didn't file his final written address, so I'll go straight to the court's decision. The court noted that the claimant failed to file his final written address in Stanbic IBTC Bank versus Long-Term Global Capital. The Ogunia JCA held that it is important to catalog the gains of final address as contemplated by the sacrosanct provision of Section 294 sub 1 of the Constitution as amended. Address of counsel, though unable to cover lack of evidence, are designed to aid the courts to appreciate the nature, the strength, and weakness in the cases of parties. It has the potential to bend the scale of justice in favor of a party who presents scintillating address laced with alluring lexical dexterity, demonstrative of impregnable advocacy. It is on account of its benefit to the court that it ranks second in the corpus of the 3 most important elements of a trial, the first and the last being hearing of evidence and judgment respectively. End of quotation. COKK versus State. It is tried that failure to address the court will not be fatal or cause miscarriage of justice. It is so because whether counsel addresses a court or not, the court must do its own research with the sole aim of seeking the truth and determining which side is entitled to judgment. The claimant is seeking declaratory reliefs that his abrupt disengagement from employment via his letter dated 24 June 2022 is wrongful and against extant labor laws. The constructive disengagement and termination was contrary to the claimant's terms of employment and global best practices. The first issue for determination, as stated above, is whether, considering the totality of the evidence adduced by the claimant, he has proved that he was disengaged wrongfully. This issue is both crucial and central to the case of the claimant, who has asserted that he was wrongfully disengaged. The state of the law remains right that it is for he who asserts to prove the assertion by adducing credible, cogent, and admissible evidence in support. See sections 131 and 132 of the Evidence Act. A plethora of judicial decisions from the appellate courts, for instance, Dasuki versus FRN, Adulaye Ogbere versus Adamu Ukpo, are in support of this statutory provision. The proof required may be oral or documentary or even both. See Anifowoshu versus Wema Bank and Aliyu Simon and Zewu versus Nasarawa State House of Assembly. The appellate courts have held that a servant who complains that he was wrongfully disengaged must found his claim on the contract of service and show in what manner the wrong was done. He must plead and prove the contract of service, which is the bedrock of his case. It is not the duty of the employer as defendant to prove that the termination was not wrongful. See Amodu versus Amode and Kato versus CBN, citations all provided. In Nigerian, Romanian Wood and another versus Akim Bulugbe, citation provided. E. Zoba Jesse held that, and I quote, for that the Supreme Court in the case of Zide versus RSCSC held that when an employee complains that his employment has been wrongfully terminated, he has the onus to place before the court the terms of the contract of employment and to prove in what manner the said terms were breached by the employer. It was held not to be the duty of the employer to prove any of these facts. The burden is on the respondent and remains on him throughout the case. He went to the trial court to ask for certain declarations and damages for wrongful termination of his employment. He surely bears the burden of proving the wrongful termination, not the appellant. End of quotation. Thus, the claimant in the instant case is under an obligation to exhibit his contract of service comprising the terms and conditions of his employment. Once that is done, the claimant is expected to thereafter draw the attention of the court to how the termination of his employment was both wrongful and illegal. The claimant in proving the wrongfulness of the termination of his employment, aside from amendments in his pleadings, tendered 6 exhibits. They were admitted in evidence and marked as Exhibit C1 to Exhibit C6. The terms and conditions of employment of the claimant are as provided in Exhibit C6. Article 11 provides for probation and Article 12 provides for termination respectively and is produced here for ease of reference. Article 11, probation period. 6 months during which, and I read, 6 months during which either party may terminate the employment by giving the order 2 weeks notice or basic pay in lieu of notice, provided that the employee may be dismissed without notice or basic pay in lieu for gross misconduct. Article 12, termination of employment. On confirmation of appointment, either side may terminate the employment by giving to the order 1 month notice or 1 month basic salary in lieu of notice, provided that the employee may be dismissed without notice or basic pay in lieu of gross misconduct. It is the claimant's testimony that after his offer of employment was dated 10th of September 2021, he was to be on probation for 6 months before confirmation, but he was never confirmed. This fact was never rebutted by the defendant. The fact that the claimant has spent more than 6 months in employment of the defendant in excess of his probationary period permits the court to deem his appointment as having been confirmed. The burden of proof rests on the employer, in this case, the defendant, to adduce credible evidence justifying the delay in issuing the letter of extension of probation or confirmation. In Obafemi Awolowo University versus Onabanjo, citation provided, the Court of Appeal, per Akpabio Jesse held, and I quote, the appellant had delayed unnecessarily in making up their mind whether to terminate or confirm respondent's probationary appointment by keeping him for 4 months after the probationary period of 3 years had expired. They would be deemed by operation of law to have confirmed his appointment, and the doctrine of estoppels by conduct would operate to prevent the appellant from alleging and treating him as if he was still on probation. Delay defeats equity. See also the case of Council of Federal Polytechnic AD versus Olowokere, citations provided. In the circumstance, the condition for his termination would be deemed to be on the status of a confirmed staff. By the provision of Exhibit C6, on confirmation of appointment, either side may terminate the employment by giving to the other 1 month notice or 1 month basic salary in lieu of notice, provided that the employee may be dismissed without notice or basic salary in lieu of gross misconduct. His letter of disengagement, Exhibit C2, is dated 4th June 2022. That means he had served the defendant for about 8 months. And since she is deemed a confirmed staff, the procedure for terminating his employment shall be by giving to the order 1 month notice or 1 month basic salary in lieu of notice. There is, however, a proviso that in cases of gross misconduct, the dismissal shall be without notice or basic pay in lieu. There is no reference to a misconduct in the pleadings, so the court shall restrict itself to the first arm of Article 12. During cross-examination, the claimant confirmed that he was given 2 months' notice, and for that period, he did not work but was paid his salary, even though he was entitled to 1 month notice by what was provided in Exhibit C1 and Exhibit C6. In rebuttal, DW1 tendered Exhibit D2 and D3 to evidence the fact that CW1's performance/contribution are not visible, end of quotation. And his line manager had communicated with DW1, who was the head of HR, and requested for a proper closure of the employment to create room for engagement of suitable hands. And on the 2nd of June, DW1 as head HR directed HR business partner to pause with the issuance of the termination letter until there was a feedback from a scheduled meeting where the claimant was to meet with an officer. From the testimony of DW1, this court is convinced that the terms of contract of service, which is the bedrock of any case where the issue of wrongful termination of employment calls for determination, and employment can only be said to be wrongful when it was done in breach or violation of, or in a manner not contemplated by the agreed terms and conditions set out either in the contract of the employment entered into by the parties. The claimant did not lead any credible evidence to show that the defendant breached any clause in Exhibit C1 and Exhibit C6. His pleadings did not direct the court to a breach, neither was there any evidence in that regard. In view of the claimant's testimony and evidence tendered in Exhibit C1 and C6, this court is convinced that the disengagement of the claimant's employment was not wrongful. The defendant went overboard to meet the terms of his appointment by giving him 2 months' notice and paid his salary for the period without rendering service to the defendant. The disengagement was not abrupt. 2 months' notice was enough notice. This is the finding of the court. Release 1 and Release 3 therefore fails, I so hold. The second relief is for a declaration that the said constructive disengagement and determination of the claimant's employment by the defendant was contrary to the claimant's terms of employment and global best practices. This court in suit number NICN/LA/33/2017 before Honorable Justice Esuwe in Mr. Tunde Ajoto versus Around the Clock Security Company Limited, delivered on November 19, 2024, has described constructive dismissal to be, and I quote, when an employee does not resign voluntarily, but because the employer has created a hostile or intolerable environment or deliberately made the workplace unfavorable. This court in Ms. Ebere Ukoji versus Standard Alliance Life Assurance Company Limited held inter alia, and I quote, globally and in labor employment law, constructive dismissal, also referred to as constructive discharge, occurs when an employee resigns because his or employer's behavior has become intolerable or heinous or made life difficult that the employee has no choice but to resign. Given that the resignation was not truly voluntary, it is in effect a termination. In an alternative sense, constructive dismissal or constructive discharge is a situation where an employer creates such working conditions or so changes the terms of the employment that the affected employee has little or no choice but to resign. Thus, when an employer makes life extremely difficult for an employee to attempt to have the employee resign, rather than outright firing the employer is trying to create a constructive discharge. The exact legal consequences differ from country to country, but generally, a constructive dismissal leads to the employee's obligations ending and the employee acquiring the right to seek legal compensation against the employer. The employee may resign over a single serious incident or a pattern of incidents. Generally, the employee must have resigned soon after the incident. End of quotation. In the instant case, Mr. Abayomi Femi did not resign his appointment. The court noted that his confirmation letter was not issued at the end of the 6-month period as agreed in the offer of appointment, Exhibit C1. That notwithstanding, the defendant terminated his employment on the status of a confirmed employee. This court, having evaluated the sequence of events that led to the termination and the evidence stand that the claimant has not pleaded any intolerable or heinous behavior to have made life difficult, that the employee had no choice but to resign his appointment. In this case, the disengagement was with reference to his performance. In view of the above failure to prove same, relief 2 fails and is dismissed. Relief 4. For relief 4, the claimant is seeking the sum of 1,900,000 naira as his unpaid salary arrears from September 2022 to January 2023. In Exhibit C1, the annual salary was provided for in Article 2. His monthly pay was 350,000 naira. The claimant is seeking for 5 months' salary. The claimant, in a statement of fact nor witness statement on oath, did not plead facts that he was being owed salaries and how the arrears were calculated. The courts have frowned on the courts going on a voyage of discovery. See Banke versus Akure North Local Government, where the Court of Appeal held that it neither goes on voyage of discovery nor does it engage in speculation. Rather, it depends on the materials placed before it in reaching its decisions. See Onagorua versus Adeniji, NNPC versus Fanva Oil. Citations all provided. In NNPC versus Fanva Oil, Jumbo offered Jesse at pages 422 to 433, paragraphs H to D, and I quote, stated, in the same vein, the court cannot even go on to award payment of arrears of salaries and allowances, more so as there is indeed no evidence before the court on which to base the calculation. A simple arithmetic, end of quotation. A simple arithmetic shows that the monthly fixed gross salary was multiplied by 5 months to get the amount being sought. The court also noted that Article 4 provides for bonuses /13th month annual salary, which is equivalent to 1 month's gross salary, which is payable in November every year. This claim cannot be granted as the claimant has not convinced this court on how he arrived at that sum. In view of this relief fails, I so hold. There's also a claim for 50 million naira as general damages. The rationale for award of damages is litigated matters of this kind has been further elucidated in Shuka versus Abubakar citation provided, where the court stated, and I quote, the basic object of award of damages is to compensate the plaintiff for the damage or injury or loss he had suffered as a result of the action of the defendant, premised on the guiding principle of restitution interregnum, that is, putting the plaintiff in a position in which he would have been if he had not suffered the wrong for which he is being compensated, end of quotation. In the instant case, the claimant has failed to convince the court that his termination was wrongful. His pleadings and evidence failed to show the damage incurred that he needs to be compensated for. In the circumstance, this court dismisses this. The claimant is also seeking for an order for 5 million naira as solicitor's fee and expenses for prosecuting this case. There is no proof of how and to whom these monies were paid and how they were incurred. In the circumstances, there is no fails accordingly and is dismissed. I make signed. So this is the judgment of the court.
My Lord, we want to thank my Lord for a very well considered decision, very erudite. My Lord went even way beyond our final address. We're very excited. It's a good way to end the year. We're grateful to the court for its diligence in coming to this decision. Very much obliged, and we wish my Lord and every other member of the court a very prosperous 2025 ahead. My Lord, we are grateful.
All right. Thank you. Okay. So I'm going to leave the meeting now. Registrar.
Okay, Registrar, thank you.
Okay.
When do we come and apply for CTC? New Year,
That
abi?
should be legal year, yes. Yes.
Okay, that's fine. When we come, we'll also do our Christmas and New Year.
No, no problem, no problem.
Thank you.
Okay.
God bless.
Bye.
Enjoy the rest
And
of
you,
the. Bye-bye.
bye-bye.